Good afternoon from Strasbourg and welcome to the European Audiovisual Observatory conference on the new Digital Services Act package, a paradigm shift. We have viewers not only from Europe, but also from Mexico, Brazil, South Africa, Canada, and Taiwan. So hello and welcome to all time zones. I will now ask Suzanne Kolczeff, Executive Director of the European Audiovisual Observatory, to open the conference.
Good afternoon and welcome also from my side to the conference, where we will have a first look at the new EU rules on online services and their possible impact on the audiovisual industry. Now, today we greet you actually from Strasbourg on a particularly sunny day, but some of you would know that normally this event would be held in Brussels, which sadly enough we cannot do for the obvious reasons. But we normally do come to Brussels because we know that's the center of action for EU policy and regulation, and we do want to reach out to our stakeholders. And to do so by serving facts and figures on the economic situation and its legal framework. Now, normally, therefore, we also choose topics that we can treat from an economic and from a legal perspective. Today, instead, we take not only first, but a very early look at a bundle of numerous rules and rules that determine the future EU legal framework. Now, they are likely to impact the audiovisual industry and to, let's say, be also very interesting for already existing legislation in the audiovisual sector. Now, how interesting is one aspect that we'll certainly explore. And what we will also hope to explore is to what extent this package is actually relevant for our sector. We hope the conference will shed light on this, and we can also say that we do not need any crystal ball to say that whatever is on the table as text today will most likely not be what the member states will finally vote on. So therefore, we thought it was really too early to put also an economic context here on the table, and we really stay with the legal only. But be prepared, as we will be, that once the, if I may say so, legislative fog has lifted, that we will also go and join in with information on the economic perspective. This is a specific strong point of the observatory, that we can do this pairing of legal and economic expertise, and we think it's really important for the sector. But what is also important for the sector, and what we have done for today, because it's also fully within our mission to enhance transparency of the audiovisual sector, is that we bring some order in, what we all, I think, perceive as very complex and complicated legal areas, so that after it can be properly discussed. We don't do that alone. For that, we have also identified and brought experts on board, and then we also have put stakeholders around a virtual table for further discussion. How all of this plays out, however, is not for me to describe. That I will leave in the hands of our skilled moderator of today, my colleague Maya Capello, who in her other life does head the Department for Legal Information. Maya, it's up to you.
Thank you, Suzanne. Let me just maybe say that today's conference will try to open a window on some of the most burning issues that concern the reform that has just been put on the table by the European Commission, this Digital Services Act package. We will spend 2 hours together and we will look at the newly proposed regulations, the Digital Services Act, so-called DSA, and the Digital Markets Act, the so-called DMA. And we will also look at how this is going to impact on the existing legislative framework, because we have already two very important pieces of legislation. On the one hand, the Audiovisual Media Services Directive, which is still being implemented by many member states despite the transposition deadline expired last September. And on the other hand, the Copyright Directive, which is due to be implemented this June, and with on one of its core articles pending in front of the Court of Justice of the European Union. As guides for this exploration tour, we will have 3 experts, and they will look at 3 angles in particular: transparency and competition in the DMA, liability and enforcement in the DSA, and the interplay between the DSA package and the AVMS directive and the copyright directive. This will be our first session. We will then follow up in a second session with a selection of stakeholders from various branches of the audiovisual industry, and they will look at what they think will be the possible impact of this package on their area of business and action. During both sessions, we welcome questions and comments from the audience. You will find the Q&A box and the chat box on the right-hand side of your screen on the toolbar. There is no need to wait for a specific moment to interact with us. You just do it throughout the conference, and then we will pick it up at the good moment. But before we kick off the first panel, we will now show an overview video of Francisco Cabrera. He is Senior Legal Analyst at the European Audiovisual Observatory. Lean back and enjoy.
Hello everybody. Let me start a short presentation with a riddle. What do a cat, a Russian doll and Hercules have in common? Believe it or not, the answer is the Digital Services Act package. You all have seen funny videos of cats on the internet, haven't you? But this is a rather recent development. I am sure that most of you still remember the good old times where you could not share YouTube videos of kitties with your Facebook friends or tweet about it with just a click on your smartphone. You probably know that those services are regulated at European level by a rather old legal instrument, the so-called Directive on Electronic Commerce, also known as the e-commerce directive. One advantage of the rules contained in the Directive on Electronic Commerce is their simplicity. They are straightforward, everything is clear. They also have clear effects. Like a modern Pontius Pilate, service providers can virtually wash their hands off whatever users do. In theory, at least. So what is the problem with this directive? Well, for starters, this directive is a regulatory answer to problems apparent in the year 2000, a world without Facebook, YouTube, and smartphones. And very importantly, despite its given name, the e-commerce directive regulates much more than just commerce, because these services have an impact on freedom of expression, on cultural diversity, on copyrighted works, even on free elections. Now, the question is whether this simple, straightforward legal solution is fit for purpose in 2021. That is, in a world that has become way more complicated. Of course, the beauty of the e-commerce directive lies in its simplicity. Adding layers of regulation increases complexity, which could lead to confusion, overlapping, and even contradiction between different legal norms. Moreover, the fundamental freedom of expression limits the legislator's room for maneuver. Another option could be to leave the policing of the internet to big companies from the other side of the Atlantic. So you might be wondering, what is the European Union doing? In Europe, change has been in the making for quite a long time. The European Union has already introduced exceptions to the e-commerce directive rules in 2 legal instruments. The revision of the Audiovisual Media Services Directive extended the directive's scope to cover video sharing platforms. Article 17 of the Directive on Copyright in the Single Market introduced new obligations for online content sharing platforms. Besides this, a political agreement has been reached on a Commission's proposal for a regulation on preventing the dissemination of terrorist content online. In 2019, the European Commission launched the process for the adoption of a more comprehensive regulatory package, the so-called Digital Services Act package. As a result of this process, 2 new regulation proposals, the Digital Services Act and the Digital Markets Act, were published on 15 December 2020. The Digital Services Act is a bit like a Russian doll. It provides rules for intermediary services offering network infrastructure, with special rules for hosting providers, online platforms, and very large platforms. The Digital Services Act will introduce a series of obligations graduated on the basis of the size of the service and its impact, such as measures to counter illegal goods, services, or content online, new obligations on traceability of business users in online marketplaces, effective safeguards for users, transparency measures for online platforms, specific obligations for very large platforms to prevent the misuse of their services, access for researchers to key data of the largest platforms in order to understand how online risks evolve, an oversight structure to address the complexity of the online space. As you can see on the screen, intermediary services get some basic obligations to which further obligations are added depending on the nature and size of the service. If the Digital Services Act rules look like a Russian doll, the Digital Markets Act looks more like Hercules trying to capture Cerberus. As you surely know, Cerberus was in Greek and Roman mythology the gatekeeper of hell. The Digital Markets Act regulates gatekeepers of a slightly different place, the Internet. Gatekeepers are those online platforms that have a significant impact on the internal market, serve as an important gateway for business users to reach their customers, and enjoy, or will foreseeably enjoy, an entrenched and durable position. In a nutshell, the Digital Markets Act will define quantitative thresholds as a basis to identify presumed gatekeepers. The Commission will also have powers to designate companies as gatekeepers following a market investigation. It will prohibit a number of practices which are clearly unfair. It will require gatekeepers to proactively put in place certain measures. It will impose sanctions for non-compliance to ensure the effectiveness of the new rules. It will allow the Commission to carry out targeted market investigations. As you may have guessed, the publication of these two regulations have raised hopes, fears, and most of all, questions. Lots of questions. Here are some of them. Does the Digital Services Act really introduce a Good Samaritan clause like the one found in US legislation? Will the Digital Services Act trump the terms and conditions of service providers? What is exactly meant by Know Your Business Customer? Who should be considered as a trusted flagger? Harmful versus illegal. Is it a distinction with or without a difference? What will be the interplay between the Digital Services Act and audiovisual or copyright legislation? How will data transparency be achieved in practice? What will be the role of national regulators? And what about cultural diversity in all this? Well, let's talk about it.
Hercules and the Russian doll will keep us company throughout the conference. I think they will be helpful memorizing images for the DSA and the DMA. But now, with the help of three experts, we will look into some specific angles. We have with us Mark Cole. He is Professor for Media and Telecommunication Law at University of Luxembourg. Mark is also Director for Academic Affairs at the Observatory's partner institution EMR, the Institute of European Media Law in Saarbrücken, Germany. Welcome, Mark. We have Joan Barata, He is a well-known international expert in freedom of expression, freedom of information and media regulation, non-residential fellow at the Center for Internet and Society at Stanford Law School. And Joan is also regular correspondent and expert of the Observatory in various projects. Welcome to you as well, Joan. And we have Martin Zentfleben, Professor of Information Law at the Faculty of Law at the University of Amsterdam. Martin is also Director of the Institute of Information Law, IVIR, at the University of Amsterdam, and which is the other partner institution of the Observatory. Welcome to you as well, Martin. I will start with Mark Cole. As we have seen from the video, the DMA, which is our Hercules today, introduces ex-ante rules covering large online platforms that act as gatekeepers and which now set the rules of the game for their users and their competitors. This initiative should ensure that those platforms behave fairly, that they can be challenged both by new entrants and by existing competitors, so that consumers can enjoy a wide range of services, and also that the single market remains competitive and open to innovations. Now, more precisely, these gatekeepers should avoid unfair practices, and they should also comply to share data. So my question to you, Mark, is how do you see this framework created by the DMA and the DSA package as a whole? And does this create a level playing field for online companies? The screen is yours, Mark.
Well, thanks a lot, Maya, for inviting me to speak at this conference and actually posing me that question that you put forward just now. Probably you would prefer me to answer with either a yes or a no, but I guess the question is so complex it needs a little bit more than just a yes or no. And I would say it's both. Yes, in the sense that the DMA offers what I would say is a really noteworthy big step forward, maybe even a leap forward, in the sense of trying to achieve a more level playing field on the digitalized online market. But no, in the sense of the DMA alone is not sufficient to create a level playing field, and it will have to be seen together with some other instruments that already exist, and obviously especially together with the DSA. Altogether, looked at it, I think we are moving towards a situation where you can say, yes, there is going to be more of a level playing field. I will go a little bit into detail with that, but obviously 10 minutes DMA overlook is not going to be sufficient to cover everything, so I will focus on a few elements. Maybe the most important is the question of scope of application. So if we compare the two proposed regulations, as we just heard in the introductory video, we have different types of providers covered by these different regulations. So in the DSA, we have online intermediaries, a subcategory being hosting providers or hosting services, a subcategory of that being online platforms, and a subcategory of that being VLOPs. And talking about VLOPs, the good thing about this new setup is we will have many new abbreviations that we can work with. We've got the DSA, the DMA, the VLOPs, or VLOPs, the very large online platforms. And then we have in the DMA providers which are covered, which are offering core platform services and can be regarded as gatekeepers. I refer to them as LOPs, large online platforms, which have a systemic relevance. Now, I have to say the word systemic is actually used in the DSA in the context with the substantive provisions, and for the DMA only in the accompanying text, but actually it is the case that they are so relevant that you have to regard them as gatekeepers, these providers. Why? Because they are relevant for both the dimension platform to businesses, but also platform to consumers. And the relevance for the businesses is that these businesses cannot offer their services to consumers without using the gatekeepers, and that makes them systemic. And so we have large online platforms, or the gatekeeper expression, by the way, an expression which we already had 20 or 30 years ago when we were talking about infrastructure gatekeepers, may be comparable to that. These gatekeepers are defined in Articles 2 and 3 of the DMA, providers of core services, which is a wide range of services, but just to show the potential overlap also with the DSA, it includes VSPs, for example, video sharing platforms. It includes advertising networks, and that is really very relevant also for the audiovisual sector that they were included. And these services have to have a significant impact on the digital single market. They have to be core services in the sense that they're an important gateway for the businesses on their interaction with consumers. And They have to be, and this I find very remarkable, in an entrenched and durable position. We heard that expression already before. And obviously both of that is in a way new, it's a new terminology, and we still have to then develop criteria what exactly is entrenched and durable. What is very interesting is that not only when you are already in such a stable position on the market, because you're entrenched and durable, you can be regarded as such a gatekeeper, but also when it is only incoming, in being. And that's very good because the DMA therefore is also proactive in the sense of it looks forward, it looks ahead with a prognosis element. And then there are further criteria developed on how such a gatekeeper can be identified. So that includes numerical criteria, the turnover, the customer reach, which basically is roughly the 10% of the population is taken as a measurement, but also that you've got more than 10,000 business users that are actively relying on these platforms. So there is a certain amount of criteria given, including that it has to have a stability over several years, or at least a prospective view that there might be the stability in the coming years. Also, the very interesting element is that the platforms have to themselves declare that they fall under this category of gatekeeper, applying these criteria. And because we don't want to rely only on platforms declaring themselves, the Commission has strong investigatory powers and can even declare such a gatekeeper to be a gatekeeper, even if they don't fulfill all of the cumulative elements, if one of them has been fulfilled in a very remarkable manner, for example. And this process we will call the designation of gatekeepers. So basically there's like a registration process if you want, but in another way, we get a list of designated gatekeepers for whom then certain obligations apply. I will come to those obligations in a moment. But before I do that, I would briefly highlight a second element, and that is what is the aim of this DMA? Well, if you look at it, it is indeed closely related to competition law. And many were expecting that the DSA package would contain some form of reform to the competition law. But no, it is noteworthy that the DMA is not based on the legal basis for competition law, secondary law, so not Article 103 of the TFEU, but Article 114, which is the single market clause. So it's based on the same legal basis like the DSA. I find that noteworthy, because certainly the case is that competition law framework would have needed an update, but instead it has been chosen to take the perspective of the DMA, probably in order to make sure it's not only a retroactive possibility to react to market failures, but it is a proactive element. It's an ex ante form of regulation where certain obligations exist just because you are a gatekeeper platform. And that's why I think this approach was very reasonable and good. What's the aim in the words of the DMA itself? Well, to create a contestable and fair market in the digital sector. And that again are expressions that contestable is maybe not so evident as a fair market. And some of the other language versions actually offer quite a clumsy expression. For example, the German version is bestreitbare Märkte, and I'm not as being very practical or having a notion connected to it already. So these platforms, which fall under the definition, in order to have these fair and contestable markets, fall under certain obligations. And these obligations are spread. There are a lot of do's and don'ts. Interestingly enough, most of them are characterized by basically enabling other parties, not only consumers, but other parties to succeed on the markets, even though they may be dependent on the gatekeeper core platform services. So in a way, that's like an essential facility approach that we know from competition law. If you have to rely on a platform to be able to offer your services to end users, well, then that platform should also open up its platform to your use. And also it gives users more control of the way they use the service. So there is a second layer on that as well. I cannot go through all of those obligations and the do's and don'ts, but I do want to mention very few. The overarching idea is there should be more transparency in the market. The platforms that are gatekeepers should make their effort that everyone can understand how they function and can basically check whether they're being treated fairly. And instead of using the expression fair, you could also say their business models have to become more open. And that's at least my wording that I'm saying. It's a type of business practice, at least vis-a-vis business users of the platforms, which says we are not using negative business practices. So, for example, you make clear what type of data you're using it, and that data that you use, you make accessible to the business services, at least the ones that created that data in the first place. There should be no free riding on data which was created by others. There should be conditions which allow for real competition. So no favoring of own services, no exclusivity arrangements, no walled gardens, as has also been mentioned before already. Generally speaking, fair and non-discriminatory practices, especially, for example, for ranking. And then the second element is this transparency. And transparency means there's going to be information available about advertising schemes, about prizes being paid, so that the market can actually check what is happening here. There's access to performance measuring tools so that the businesses that use those core platform services can check whether or not the results they're achieving are really what has been suggested to them. Access to data that is being created when third-party services are being used. Data where you can derive from how you end up on the ranking in the search engines. Data about profiling techniques. And there has to be even an audited report about these profiling techniques that are implemented. So generally speaking, a lot more information will be made available. We will have less of a black box in the platform surrounding and more of an open, clear space, which I think is a very laudable move forward. And maybe the last points I want to make to conclude is, where are the member states in this? Because the enforcement powers rest with the Commission. The Commission will get very strong enforcement powers, including sanctioning powers. But what about the member states? Well, the DMA seemingly blocks member states from imposing further obligations on gatekeepers. Yes, but at the same time, it acknowledges, I quote, that this is without prejudice to rules pursuing other legitimate public interests. So, for example, transparency arrangements for the benefit of media pluralism, of more availability of media content, would be something that a member state, at least in principle, could impose, even though the DMA is otherwise completing this sector. And then the final point I would like to make is, we don't only have the issue that there has to be some form of arrangement between the DSA, which Martin will talk about, with the other existing secondary law like AVMSD and so on, but we also need to have clarity between what is in the DMA and what is in the DSA. So Joan will, for example, talk about the question of liability. What I'm interested in is also to know, well, if we have liability rules which also apply to such gatekeeper platforms via the DSA, how does that relate to their obligations under the DMA? The DMA acknowledges that we have the platform to business regulation, which stays in place. We have competition law rules, which stay in place. We have the consumer protection acquis, which stays in place. We have AVMSD. So there is a lot there that stays in place, but we also need a clarification between DMA and DSA. And therefore, I'm looking very much forward to the further discussion in the conference today. Thanks a lot for that.
I think, Mark, if you agree, you try maybe to reconnect, and when we will have the discussion, you can complete your final remarks. So for the moment, everything was very clear. What we heard was inspiring, and it showed also very clearly how complex this package is. But there are also other elements to consider, and you just mentioned one of them in your closing before you disappeared, which was the liability issue. And here I would like to ask Joan Barata to introduce us to one of the trickiest issues of our Russian doll, the DSA. So the Digital Services Act introduces new rules framing the responsibilities of digital services to address new risks or old risks that the users are facing, and also to protect their rights. And these new legal obligations, they also aim to ensure a modern system for cooperation, and also systems to guarantee an effective way of enforcing these rules. More precisely, the DSA introduces a gradual approach. We have already had an idea of the scope with these different sizes of the platforms. And we have also a European adaptation of the so-called Good Samaritan principle, which comes more from overseas. So I would like to ask you, Jean, what could be, from your point of view, the effect of these rules? The screen is yours.
Thank you. Thank you very much, Maya. It's a pleasure to be here. Thank you for for the invitation, and I'm glad to virtually see a few good old friends. It's been a while with some of them, so I'm glad to see you at least in this format, and I hope that my connection remains stable. So, well, talking about liability, we have, there's this principle of liability exemptions applicable to intermediaries that has been there since the very beginning of, let's say, internet legislation. We have that incorporated into the e-commerce directive from the year 2000. We saw that, but even before that, the Section 230 of the Communications Decency Act in the United States, which is called by some the 26 words that created the internet, already incorporates this principle in a very strong manner, by the way, because according to Section 230, platforms are not liable at all for content provided by a third party, but also platforms are not liable for the content that they take down. So not only for content that they leave up, but also for content that they take down. You have a general exemption here. The second one is called the Good Samaritan principle that, is basically, protected under the Section 230, and it was not much protected. It was not incorporated into the e-commerce directive, at least to the extent it is present in Section 230. As it has been mentioned already, Article 14 of the e-commerce directive establishes a certain principle of liability exemption, but there are basically two exceptions. First exception refers to cases when intermediaries reach knowledge or awareness of the legality of a piece of content, and of course the second refers to the cases when they don't act expeditiously removing that piece of content or disabling access to it. Basically how this knowledge can be achieved. One possible way, of course, is via a valid and substantiated notification, but I think that the most important element here for this discussion is when platforms may become knowledgeable or aware of a piece of content that is illegal as the result of their own initiatives, their own investigations in the application, for example, of their own terms of service. And here, the case law of the European Court of Justice has, let's say, adopted a principle that some say that is not in the directive when it comes to hosting services, but now, we can say that the case law has, transferred it, also considers it applicable to hosting services. That basically says that intermediaries enjoy liability immunities inasmuch as they perform a role of a mere technical, automatic, and passive nature. So, here, apparently the case law has built some sort of a distinction between passive and active platforms. And in the case you're an active platform, you have the risk that your liability shields disappear. As some, let's say, authors has mentioned, making the protection conditional on passivity would probably induce a hands-off approach that may result even in an increased quantity of online illegalities. I think it's important to mention that the idea of the Good Samaritan clause, saying that you are not liable for the content that you leave up or the content that you take down, is precisely to incentivize platforms in their task of moderating content and, let's say, eliminating not only illegal but also objectionable content. Also, something important to mention here is that particularly recently, European institutions have acknowledged that the adoption of certain voluntary proactive measures to monitor, to detect, to remove illegal content does not necessarily lead to lose the benefit of the liability exemption. And for example, in the case of the copyright directive, but I would particularly mention the cases of the codes of conduct in the field of tackling illegal content online, disinformation, the communication and the recommendations of the European Commission with regards to the role of platforms tackling illegal content, kind of say that if platforms adopt an active role to deal with certain types of content, this active role does not necessarily lead them per se to lose their immunity vis-a-vis possible liability claims. This is, a little bit still unclear, open to interpretation, because here we see this in documents of the European Commission and the case law of the European Court of Justice, particularly in the L'Oréal case, is not 100% clear where we put that line between active and passive, but these are the principles applicable, at least within the context of the e-commerce directive. What happens with the DSA? The DSA incorporates the same idea of liability exemptions with exceptions, and in this sense, Article 5 of the proposal is quite similar to Article 14. When it comes to, let's say, notice and takedown procedures, I would say that Article 14 of the DSA establishes a procedure that is very formal, and it does not seem to require that notices are properly substantiated. But I think that this is a mistake in the drafting process, and this will be amended, because I'm sure that this is not the intention of the drafters. But what I would like to stress here is the existence of, if I can call it this way, an additional layer. What I have just explained doesn't disappear with the DSA, but here we have an additional layer. This layer is incorporated via the so-called obligations to mitigate systemic risks that are basically imposed on very large online platforms. So in the DSA, and this is a very new thing, very large online platforms are obliged to make an assessment of the systemic risks that they create, and on the basis of that, adopt certain measures to mitigate those risks. And here, these risks do not only refer to illegal content, but also they refer to dissemination of content that can be considered also as harmful. That is to say, something that is objectionable and goes beyond illegal. So this is something that, again, the DSA incorporates as a new obligation for platforms. And of course, this may force platforms to take certain initiatives, because otherwise regulators may even punish platforms that do not take these measures. In order, let's say, to mitigate, if I may use also this verb, the effects that this may have on liability exemptions, there's an article in the DSA proposal that says that platforms do not lose their liability exemptions solely because they carry out voluntary own initiative investigations or other activities in order to deal with illegal content or objectionable content, according to what I just mentioned. Here, what we have is some sort of a Good Samaritan clause. That is true, because it seems to incentivize this activity and to protect these activities of the platforms consisting of detecting illegal and objectionable content. And it says that the adoption of certain measures or certain initiatives aiming at dealing with these specific kind of content does not lead per se solely to lose their immunity. Problem is the use of this adverb solely. What does it mean exactly? What does it cover and what it does not cover? And here, this is something that is still open to interpretation. There have been many discussions about experts. It seems that if there are other elements that may indicate that platforms are aware of the existence of an illegal piece of content and they have overlooked it, then the solely does not apply anymore, because there are other elements that indicate that there's knowledge. So in this case, we can say that this is not per se or the same Good Samaritan clause as we can point in the section 230 DSA, because there's this very limited scope, solely because of the fact that they take certain initiatives, which means that, of course, they may be considered to be liable if there are other things that may happen and may indicate that they have knowledge. And to conclude, also, I would say that, I mean, apart from the disincentivizing effect that this may have on platforms, these may become even more problematic if we think about other initiatives that platforms may take aiming at applying their own terms of service beyond the obligations that they have in the DSA. And there it seems that these possible actions are not covered at all by this partial Good Samaritan clause incorporated into the DSA. So, a few new things. The main principles remain the same. There are a few new things that indicate the incorporation of to a certain degree of a Good Samaritan principle, but there are still many question marks as to how and to what extent this Good Samaritan principle protects many different possible measures that platforms could take at some point. Thank you very much.
Thank you very much for this. I think we will definitely hear a lot about this in the months to come. It's an incredibly interesting discussion with many nuances, and the more you read it, the more you get lost in the details. So thank you for this run. But we are not done. We need to complicate the situation even a bit more, adding a third layer of information. So as I mentioned in the very beginning, the new DSA package enters on a stage which is already quite crowded. So I would like now to ask Martin Senftleben to enlighten us on this regulatory interplay that is going to happen. Because here the issue is that the Digital Services Act sets the horizontal rules covering services, all services online and all types of illegal content, including goods and services. And it does not replace or amend, but it complements sector-specific legislation, such as the Audiovisual Media Services Directive, the Copyright Directive, but also the Consumer Protection Acquis. There is also a proposal for a regulation on preventing the dissemination on terrorist content, and we have the telecom rules, the data protection packages. We have plenty of rules out there. But let's focus on our audiovisual sector. Since both Copyright Directive and the Audiovisual Media Services Directive are mentioned as lex specialis with regard to the general rules of the DSA package, my question to you, Martin, is how will this regulatory threesome work in practice? The screen is yours.
Well, thank you so much, Maya, for the kind introduction. And of course, it's a pleasure to be here. I'm very happy to receive this invitation to contribute to our debate today. Well, if only I knew is the short answer to the question you have put in front of me. Let's start by having a look at Article 1.5 of the DSA, where we already understand that, as the title of my presentation says, lex specialis, this is not exactly what the provision itself says. 1.5 of the DSA says without prejudice. So the rules of the DSA are without prejudice to the other more specific pieces of legislation that have already been mentioned several times. So we have the AVMSD, and we have the new copyright legislation, and there is anti-terrorist legislation in the making. Well, when we look at this, we will immediately understand that we get quite some complexity if we understand this without prejudice language as a strict lex specialis approach in the sense of legal silos, that you have to know exactly in which category a certain service or a certain medium is falling in order to find the right rules. The complexity will be enormous because there is so much difference between the regulatory approaches. When we look at illegal content, then of course we know with regard to criminal content there are specific bans or appropriate measures to be taken under the AVMSD rules, also concerning now video sharing platforms. In copyright, we just have this new package with Article 17 that basically puts an end to the traditional safe harbor approach with regard to online content sharing service providers. And then on top of that, now with the DSA, we have a reinforcement of the general safe harbor approach, a continuation of that approach, as the new legislation says several times. But it has also been pointed out already, there are, of course, quite a number of refinements, additions, we could say. We have the specific risk assessment and mitigation duties for the very large online platforms in Articles 26, 27. We have notification obligations as to suspicious content with regard to online platforms in 21 DSA. And we have the more traditional hosting regime in Article 5 DSA. So already with regard to illegal content, quite a number of different rules that have to be harmonized in some way. When we look at harmful content, the situation, I would say, is even a bit less clear. There are specific rules on harmful content in the AVMSD. I guess you are all specialists in that area, so I don't have to say much about it. But with regard to the DSA, the explanatory memorandum on page 9 already tells us that it's basically not intended to regulate harmful content to a large extent. It says that the new rules in the DSA should not cover harmful content in the sense of imposing removal obligations in the light of concerns about freedom of expression. This, however, does not necessarily mean that the new DSA rules will not have to add something with regard to harmful content. When you zoom in a bit and you look at it in more detail, you see in recital 52 of the DSA that harmful content is reappearing in the context of online advertisement and the risks that can arise there with regard to specific targeting of audiences, profiling, and so there should be transparency with regard to the logic that is underlying these advertising systems. I also believe that the systemic risks approach that concern very large online platforms in Article 26 DSA will introduce certain obligations with regard to harmful content. 26 DSA explicitly refers to the prohibition of discrimination and the rights of the child. So this can also cover harmful content. So in a nutshell, I think if we understand this lex specialis without prejudice language in the sense of clear silos, that we have to decide in each and every case whether a service falls under one or another category, then we will end up in lengthy discussions about how to draw the lines, boundary lines between these different approaches and regimes. Good news is that the DSA itself already says, well, perhaps it is not that strict. First of all, we see a couple of interface provisions, you could say. There can be a direct interface between the rules of one legal regime and the other. 27 DSA, again, with regard to very large content platforms, has a direct interface with 17 of the DSM Directive by saying that in order to mitigate systemic risks, there can be a need to introduce proportionate and effective measures, including content moderation. The rules in 17 DSM Directive can then be understood as adding flesh to the bones and explaining what these content moderation duties really are. And of course, the memorandum on page 4 also says very clearly that the lex specialis is to be understood in the sense of complementing each other. So to the extent that there are no specific provisions in the AVMSD and the new copyright legislation, of course, the rules of the DSA will cover that space and will add to that space. And I think this is actually a very strong feature of this new legislation because it can also correct a couple of policy issues that have been doubtful in the past. So I think many useful additional rules enter the picture, things that have been missing in these more specific pieces of legislation. I give you a couple of examples. First of all, I think the transparency obligations in the DSA are really helpful. what I read in Articles 13 and 23 about transparency with regard to content moderation measures really gives hope that this will not be a complete black box system. We know that Article 17 of the DSM Directive is currently under review for the Court of Justice, and one of the concerns is, of course, that even though Article 17 of the new copyright legislation refers to notifications of specific works, there can be a risk of a snowball effect, lengthy list of notifications of works that finally leads to a prohibited general monitoring obligation in the sense of Court of Justice case law and the statutory ban on general monitoring obligation. So it is good news to see that there is a transparency rule added to that in the DSA that will allow the general public and watchdogs and so on to really check what is going on in this area and whether the content moderation activities reach perhaps a volume that is problematic in the sense of the Court of Justice decisions, in particular in Scarlet Sabam and Netlock Sabam. Then I think that we have added value with regard to the system of trusted flaggers. This is also something that has not been developed in that sense in the more specific pieces of legislation. So Article 19 on trusted flaggers is definitely added value. I think it's in particular seen as good news in the audiovisual sector that recital 46 says that with regard to intellectual property rights, organizations of industry and right holder organizations can be awarded trusted flagger status. I know that the audiovisual sector has argued for that, and so I guess this is seen as a success. I don't want to ruin the party in this respect, but personally, I have at least one concern there, and this is the boundary line between piracy, which nobody wants to see online, and parody, which from a freedom of expression perspective is something that we want to see very much online in an open democratic society. So I have doubts whether right holder organizations will always be able to find the right balance there when making distinctions between piracy and parody. There have been quite a number of cases against parodies, mashups, pastiche, caricature, and so on, things that right holders perhaps may assess much more critically than the general audience, and how it should be assessed in the light of Court of Justice jurisprudence. Good news in that respect is that, of course, Article 19 DSA also says that these trusted flaggers must act in a diligent and objective manner. So if the audiovisual industry gets involved in these processes, they have to ensure that there is a diligent and in particular objective manner of assessment, objective in the sense of taking the guidelines of the Court of Justice into account. And then good news also is that we have the provisions on misuse in Article 20 of the DSA, and this has two elements, two aspects. On the one hand, of course, these misuse provisions concern recipients of a service, users of an online platform, for instance, that frequently provide manifestly illegal content. So those users who are just let's say, lost cases, who will never understand what illegal means and that it is not the intention to upload illegal content. But at the same time, the misuse provisions also cover individuals or entities or complainants that frequently submit notices or complaints that are manifestly unfounded. So there is a balance there. There is a misuse provision not only with regard to illegal uploads, but also with regard to manifestly unsubstantiated allegations of infringing material.
So we have some backdoors that we can escape out of the situation from in case.
There are backdoors, and there are quite useful additions to the general, more specific, to the more specific provisions in the AVMSD and the new copyright legislation. This just as an
Thanks a
introduction.
lot.
Thanks so much.
Yeah, exactly. I think you could continue, and the discussion could continue for a long time. It's so complex. The more we read it, really we discover many new things. So now questions are starting to pop in from the audience. You have all three triggered lots of interest. I would like to try to give Mark Cole the chance to go back on screen if he has managed to get back again. And now you have also heard your colleagues. So I would like to mix a question from myself with one I see from the audience. Very short, 1 minute, telegraphic. Is this balanced? DSA, DMA, they go together, but how is the overall balance between the two? And then I have a question for you. If you have any take on the meaning of active users in the DMA. And then there are questions where maybe we don't have data still, but I throw it there to all of you. If we have an idea of how many platforms we are talking about and dimensions of them. I am at the observatory, we are still working on that, but if you have, happy to take them. Mark.
I will actually, your question is perfect in the sense that what you missed from what I wanted to say was we don't have to be careful to look at this network of regulatory pieces that Martin just talked about, but we also have to make sure that the interaction between DSA and DMA is thought through very well. Because on the one hand, as I said initially, we've got this issue that the question is basically the DMA reserved only for very few platforms in relation to the DSA? Yes, likely, because to be a gatekeeper, you have to fulfill these different criteria. But how does it play out that this prospective view on it, that somebody who may get into an entrenched and durable situation already plays into it? So basically already a LOP, a gatekeeper in the making. So I think we still have to look at, do platforms exactly know which obligations get applied to them from DSA and DMA? So this interaction is important. And in that sense, yes, a very good question. What's the individual elements? And one of them, the question of active end users, the same like having 10,000 active business users per year. There I see an issue in the sense that the Commission is empowered to lay down further guidelines on that as well through delegated legislation. But at the end of the day, we could theoretically end up before the court to answer that. But the reality is, there will be a number of platforms for which there is no doubt. And there's not going to be a huge number. I can't provide numbers, but we are not talking about a huge number of platforms which will be under the DMA. And therefore, my guess is the 45 million will not be relevant. The 10,000 will not be relevant because where it gets relevant, it is well beyond that. I hope that's okay for a first.
Absolutely. Thanks for that, Mark. We will look into the numbers. Absolutely, we will follow that. I have a question to Joan here, which is a bit articulated about Articles 14 and 15 of the DSA, about the user-friendliness of the notification procedure. So the question is, are we requiring online platforms to become like courts in Article 15 by demanding a so detailed statement of reasons? Does it make sense, or will it lead to refrain from blocking and removing illicit content? You touched briefly upon it when you mentioned that there could be an encouragement of doing more than necessary, but here is maybe the opposite fear. What's your take on that, John?
Thank you. Yeah, I mean, it's a complex matter. As I said, I think that Article 14 has some issues in terms of drafting. I think that as a matter of principle, the fact that the law requires at some point that notices are properly substantiated is very important, because the more substantiated a notice is, the less we are putting a platform in the place of a court. If there's something that, I mean, it's clearly presented as something that really looks illegal, and there's a clear, let's say, substantiation that is behind that, then the platforms, I mean, are not forced to make a judgment on the legality on the basis of a simple formal notice that they receive. Problem is that now, as it is drafted, I mean, Article 14 seems to refer only to very formal aspects of the notice, but not the substance of the notice. If the notice doesn't have enough substance, it is clear that in order to avoid liability, platforms will have the temptation to take down everything. because it's clear that with the notice they get knowledge. So just in case, now that I got the notice and without entering the discussion, whether this is illegal or not, what perhaps I would do is to say, okay, I take it down, end of the story. So that I think that this is the way I would see it.
Indeed, there are hopes and fears. We saw that also in the video. That these are two umbrella expressions that are relevant. I have also a question to Martin, which goes a bit in this line about on liability. So, can the experts comment on the fact that the DSA seems to opt only for removal or disablement of alleged illegal content in order for providers to escape liability upon notification? Could other less restrictive measures not also be taken into consideration in order to exempt the liability? So, Martin, you mentioned this without prejudice and illegal harmful. Is this a backdoor?
Well, I'm very happy for this question. I think it was Dirk Verhoef asking this question. Great to have your question, Dirk. Great that you also joined this conference today. Well, actually, I understand the approach as giving the right holders or organizations concerned about illegal or harmful content the first initiative to say we are concerned about this content. But I think, of course, there is room for refinement in the further cascade of actions. So, for instance, the next question then would be, if the user disagrees with the takedown, with the blocking of the content, how difficult is it to get the content up and running online again? And there in the DSA, in the copyright arena, there has been quite a vivid debate about the question how easy or difficult legislators can make it for users to bring a complaint against the takedown. And then one approach would be to say this should be really low key, very easy for users, perhaps a couple of standardized complaint mechanisms where you just click a box and you say, I firmly believe that this is permitted parody or something, and then the content would already be available again. Of course, then the next question is, can we offer a liability shield then? So if a user says, I'm really convinced that this is permissible content, and the platform then has a must-carry obligation to show the content again, then the platform would have to also enjoy a liability shield until such time that the final status of the content is finally established by an appeal or court or whatever regulatory body. So I agree with your concern, but I think this is something that we should regulate in the discussion concerning the reaction of users and how easy we want to make it for users to bring a complaint and ensure that the content is made available again.
Thank you, Martin. That I think made perfectly the point of the nuances and the difficulties. I will come back to you again, but I would now like to open the second part of the conference because we will make the situation even more complicated, adding more cards on the table by listening to the stakeholders, the actors of all this, where what will be the impact of this new regulatory package on their business and life. We have with us Richard Burnley, Director of Legal and Policy at the European Broadcasting Union, EBU. He can maybe be brought on the screen. Richard, you're there? There you are. Welcome. We have also Miruna Erovano. She is a Senior EU Policy Officer at the Association of Commercial Television in Europe, ACT. There you are, Miruna. Welcome to you as well. And we have Pauline Durand-Vial. She is Chief Executive at the Federation of European Screen Directors, FERA, and she's also Chairperson of the Advisory Committee of the Observatory. Welcome, Pauline. We have Miriam Estrin. She is Policy Manager on Government Affairs and Public Policy at Google. Welcome, Miriam. And last but not least, we have Celine Craig, Deputy Chief Executive at the Broadcasting Authority of Ireland and also member of the board of the European Regulators Group for AVMS Provided Services, ERGA. Wwelcome to you, Celine. Welcome, all of you. I will let you in very shortly. I just wanted to introduce you to show the wide span of the actors that we have. But before that, I would like to hear from Anna Herold, head of the Audiovisual and Media Policy Unit at DG Connect, European Commission, in order to set a bit the scene for the discussion. So we can maybe bring Anna to the screen. The Commission is the real engine in here. I think this is clear. You have done a lot of work that resulted in December, not only in the tabling of the Digital Services Act package on the 15th of December, but just a few weeks before, you had already tabled two important action plans, the European Democracy Action Plan and the Media and Audiovisual Action Plan. So this regulatory mosaic can be sometimes a bit difficult to navigate. We are all very eager to know also a bit more about the process. So what can we expect in the months to come, and how will this new package impact on your daily work on the Audiovisual Media Services Directive? The screen is yours, Anna.
Thank you, Maya, and good afternoon to everyone. It's a true pleasure for me to be here with you, especially having this possibility to set the scene before an industry panel, because after all, everything what we do, of course, for the industry and ultimately the users. Indeed, it's great to speak after so many distinguished speakers, and also a very nice introduction by Francisco. So indeed, I would like to maybe add a little bit or shed a bit of light on this matryoshka that it's a wonderful metaphor that Francisco proposed, and I think in a way, as also Martin and other experts explained, probably describes rather well what we have now in front of our eyes in terms of regulatory puzzle. In particular, as regards, as you said, Maya, the relationship with the audiovisual media rules. And then I would also, as you said, say a few words about the other elements of the puzzle, even broader, non-legislative elements, so the two action plans you have already mentioned, and that hopefully will make the matryoshka look a little bit more like a Barbie, or maybe not necessarily Barbie, but a nicer doll. So first, a little bit on the relationship. Now, so how do we see this undoubtedly complex relationship between the different existing and new legislative frameworks of the Digital Services Act in particular, because I think this is most relevant for the online content regulation that everybody on the panel in particular will be concerned with. So I think what I would like to stress is that in this relationship, I think what is important is to see a clear way of travel of the Commission in terms of the, let's say, regulatory philosophy that we would like to propose here in Europe. And this is based, I would say, on two main principles. First, I mean, this is obvious, but I think it's nice to keep that in mind. Also, if we look in particular, you know, on some recent events, like, you know, what has happened around during, you know, the aftermath during the transition of power in the US, how important, you know, for us it is to keep these important guiding principles in mind. So I think the first is clearly that whatever we want to devise in terms of online content regulation in the EU, it has to be based on a strong respect of fundamental rights, and in particular, of course, freedom of expression, which is, as we all know here in this conference, not only freedom to receive information, but also to impart information. And this is, I think, very visible, both in what we have done with the Audiovisual Media Services Directive, and now even more so with the Digital Services Act on the table, with its strong focus on due process, on complaint and redress mechanisms, and transparency vis-à-vis users, now in particular with the DSA as regards content moderation, the content recommender system, but already back, you know, when we have devised the AVMSD for example, as regards commercial content, and this continues now in the DSA as well. So that would be the first thing I wanted to say. The second, maybe even more important in view of this discussion, the US inspired discussion and the famous incident of the suspended account, is I think what we are trying to give sufficient thought in the EU in terms of how we regulate media online is that, to give the right answer to this dilemma of public versus private enforcement of content standards, and how we can make sure that there is a sufficient level of public involvement in how content standards are actually shaped and then enforced online. And this is something which is, again, very visible in the Audiovisual Media Services Directive that, as you know, remains the only EU legal instrument that will have direct impact on terms and conditions of platforms. Of course, there are also elements in the DSA in that respect, and also the focus that we are giving in both instruments on independent public oversight. So these would be the kind of general, I think, remarks, that I would like to all of us to keep in mind when we will be discussing a little bit more in a minute among the industry players. There's plenty to be said about both the AVMSD and the DSA and how they interrelate with each other, but maybe just a few words of how do we see the relationship, because I'm pretty sure that this is, a topic that is on everybody's mind. So as I already said, on the terms and conditions, for us, it is something which remains extremely important to see the AVMSD as the actual, common framework as to what content standards in Europe should look like and how they should shape the terms and conditions of platforms. I also want to stress that it is the AVMSD that will still remain the framework governing harmful content, mainly, especially as regards protection of minors. And also it will still remain the framework, and I think that this is important from an industrial perspective, to which I will come when I will speak now in a minute briefly about the Audiovisual and Media Action Plan. It will still remain the framework that will set the common conditions for issues around promotion of European content. The DSA, of course, will provide this overarching structure and in a way fill certain gaps that we had left deliberately or not in the AVMSD. And there may be briefly three elements that I just want to stress for discussion. First, of course, the important element which relates to how to deal with actually problematic instances of illegal content online, and what it did provide, or it does provide, in terms of the the cooperation between authorities to act against illegal content, and also for orders to receive information. Second issue, the overall transparency on online advertising, very important, and that certainly goes beyond what we have, in terms of regulation of advertising standards themselves, the content of advertising. So all these provisions on who is behind the ad, the information that it will give to the users of who is behind the ads and why certain ads are reaching us. And finally, the already very much talked about provisions on risk assessment and mitigating measures for the very large platforms, which I think nicely leads me to mention the few elements of the two action plans that, Maya, you asked me to cover. Because that's a bridge to what we have in the European Democracy Action Plan. As you know, the Democracy Action Plan looks at three big elements that are important for our democracies: elections, media pluralism, and disinformation. And the DSA for disinformation will certainly remain the overarching framework, but waiting for this framework to come, with this risk assessment and mitigation measures that very large platform will have to put in place, and the possible codes of conduct that the DSA also provides a co-regulatory framework for, we want to work on the existing self-regulatory initiatives, so the code of practice on disinformation, and try to make it better while waiting for the co-regulatory machine to be set up. So I think that would be the element of the Democracy Action Plan that I'm pretty sure will be extremely important for the industry to discuss and also comment on. We will work on specific guidance, how to make the code better, and then towards the end of the year, on this basis, we would like to convene the signatories and other stakeholders to make it better. And finally, on the more industrial front, we have mentioned that the promotion of European works and what can we make sure that our industry becomes more competitive, despite being so harshly hit by the aftermath of the pandemic. The Audiovisual Media Action Plan, with several support measures that you will have seen, but also in its third pillar, a strong focus on enforcement, of making sure that what we have already, I know it is much more sexy, and this is the conference to discuss the new package, it is much more sexy to talk about the rules that will come into play. But of course, we have also, in parallel, make sure that the rules that we already have in place and are supposed to be transposed by the member states work in practice. So that's why I'm having one sentence, Maya, just to finish. We would like to really make sure that the cooperation between national media regulators works well, so that not only the users can be protected, but also all the framework that we have for promotion of European content actually works in practice. And I'm very happy to see that Celine will be here, so she maybe can say a few words about the recent memorandum of understanding that European regulators concluded under the aegis
I'm
of
sure
ERGA.
she will, because I had a little side chat with her, so she will certainly mention the good work that ERGA is doing on this. Thank you very much, Anna. This was plenty of valuable information. The mosaic is very colorful and plenty of activities and actions for everyone. But now let's come to the core characters, those who will in the end have to deal with these rules. And I would like to start with the historical players, let's say, in the audiovisual sector, the broadcasters. And let's start then with the most historical ones, and that's you. I have the honor of representing them, Richard, today. Richard Burnley, you represent the EBU, the Association of Public Service Broadcasters in Europe. And I imagine that you as well have had plenty of discussions around the DSA. So one thing you like and what you are less happy with.
Thank you very much, Maya. Good afternoon, everybody. Thank you so much for this opportunity to speak on behalf of the European Broadcasting Union and public service media in Europe. I'll be brief is quite an abused phrase, I think, but I certainly will be, and I'm happy to be. You ask what's good about the package, and I would say loudly that the EBU welcomes the packages overall, very much so. I guess you don't want me to be quite as brief as that, so I'll expand a little bit. Of course, public service media, we support freedom to do business, we support freedom of expression, but what we can't support is an unbridled freedom to disrupt or exploit competitors, or indeed an unlimited freedom to manipulate public opinion. And this is to some extent what we face now in the digital space, or in digital and in society today, because such is the extreme power of some platforms that they can effectively operate on the business side as self-interested network gatekeepers, and on the content side effectively as a private regulator, moderating content according to their standards and norms. So So we welcome regulation. We see the need for regulation, but we also see the need for a very measured and balanced approach. And just to be clear, we don't seek isolation from competition or the undermining of free expression online. Our aim is really very much for a fair competition and a responsible and safe online environment. So overall, I would say, in answer to your question, we absolutely welcome EU initiatives, the DSA and DMA. DSA to close some of the existing loopholes for intermediaries and to oblige them to act more responsibly, more transparently, and particularly with respect to illegal content, of course. And we also look to the DMA to prohibit unfair and discriminatory practices by big tech and to give broadcasters access to their own data and to prevent misuse of our data by global platforms. So these are really important initiatives. There are some gaps, we would say, and we're still working through with our members, and so that we'll have more to say in the future. But I think key for us at the moment is that we cannot accept any private regulation of edited content that is already publicly regulated according to specific European rules. And we would say that edited and regulated content by European broadcasters and publishers should not be subject to secondary moderation or interference by platforms. So the DSA, we'd like to see the DSA include conditions to prevent global platforms acting as essentially private regulators according to their commercial standards. We need to be clear, basically, that European broadcasters answer to European laws and to European regulators only. If I may just very briefly again, we'd also like to see, and I hear what's been said today, and I'm encouraged by what's been said today, but perhaps some clearer demarcation of the EU sectoral rules that the DSA shouldn't impact, and very important for us is the member state discretion to bring vital prominence rules for general interest contents under the AVMS. So finally, overall, we thank the EU for this very important initiative, and we really look forward to working with them to make it work for European citizens. Thank you very much.
Thank you, Richard. I think you liked quite many things. There was not only one. So that's
Absolutely.
good. That's a positive start. So now let's see how the commercial broadcasters see this picture. We have with us Miruna Erovano. You represent, Miruna, if we have you on the screen, the Association of Commercial Broadcasters in Europe. So you might see it a bit differently. The business is different from the public service one. But again, there must be something you like, and maybe something you would have liked to see differently. So the screen is yours, Miruna. The microphone. No, we cannot hear you. That's bizarre. That is strange, because you should be, I ask my colleagues to check. Otherwise, we can maybe move on with somebody else and then take you in afterwards. We don't hear anything. Yeah, you make some tries, Miruna, and I call you back. We will not move too far away, because broadcasters, they often act with different hats. So sometimes they distribute, sometimes they produce. And let's go then and see what the authors do and think in all these contexts. So the DSA from their perspective. We have Pauline Durand-Vial with us. You represent FERA, the Federation of European Screen Directors. How do you think the DSA will impact on your sector? One thing you like and what you dislike or like less. Pauline.
Thanks, Maya. I'm very happy to be here as always. So just a few thoughts, because we're very early in the process, and for us as representatives of authors, we're a little bit, let's say, in the back of the immediate discussions that are already actively take place on the text itself. And I always get a sense of the excitement of people who have a deep understanding of the legal aspects of all these the process and the drafting, which always makes me, to tell you the truth, a little bit afraid as a representative of the people creating and working in this sector, because excitement sometimes goes against the sobriety you should always have in mind as a legislator when you're thinking about the impact of these rules on the reality of the working people and the business realities at play here. And since the text is so vast and so all-encompassing, thinking in a vertical way of specifically our industry and our industry segment on the creative side might be a tad tricky. So that's what we will bring to the table in the month and years to come. Basically, to answer your question, it's pretty clear to us and in our community that bringing the rule of law in the 21st century online realm is, of course, an absolutely positive endeavor to undertake for the EU. No doubt about it. Our question is going to be, how do we find the sweet spot to balance freedom of expression, freedom of artistic expression, and how do we keep on valuing properly the intellectual property, which is the lifeblood of the entire audiovisual value chain? That's it. That's our conundrum. So it brings us to this incredibly complex question. What does this whole digital services package mean for the European audiovisual creation in all its geographical, cultural, and artistic diversity, considering the various shapes and sizes of the players in our current production and distribution framework? And that's, of course, much more complicated to consider. Now, there are two buzzwords that always become very exciting straight away for us in this day and age. One is liability. Of course, in terms of copyright enforcement, the question will be, will these new rules be good or bad for our industry's current legal arsenal against online piracy, in particular in this day and age? That's a huge question, and I'm sure that Miruna will have a few things to say that I will actively cheer from my position when she'll be back in a moment. And the other buzzword is gatekeeper. Of course, I don't think we react to it the way the definition in the DMA is actually designed. For us, what the gatekeeper word triggers is a thought about the ongoing accelerated shift in consumption online and the rise of global streamers in our production and distribution market, which is raising a lot of questions in terms of connection between European rights holders and the audience, which is now very much connecting to audiovisual works through these platforms. And there the question will be, does any of these provisions help us address the gatekeeper position in the market of certain players, allowing us to maybe have a little bit more sense of audience data transparency between rights holders and platforms, as well as, of course, a number of questions that we all have about the recommendation systems, which, of course, interplay with the AVMS directive, and that I'm not going to go into. But voila, for us, that's pretty much it.
Thank you, Pauline.
Yeah, sorry.
We will see indeed now with Miruna if she's back. That I guess she'll be happy that you can cheer both of you on this topic. Miruna, shall we give it a try? Are you there?
I am here, yes. Do you hear me?
Yes, and we can see you as well. This is wonderful.
That's great.
So for you as well, one good thing and one, disappointment.
So just to say, I apologize for destroying the matryoshka that we had in this in this event ourselves. I'm coming now a bit. So thank you for having us. Thank you so much for giving us the opportunity to take part in this event that is very, very timely and very important for commercial broadcasters. Us as well have wholeheartedly welcomed the DSA package, the DSA and the DMA. I will start by saying a few words of what we like and perhaps a few words where we see more reflection is needed on the DSA, and then continue with a few words on the DMA. So we cheered on quite a lot the guiding mantra of the European Commission: what is illegal offline is illegal, what is illegal offline should be illegal online. We also believe that very much indeed. So we welcome large parts of the European Commission's work on the DSA, such as the so-called FLOP part, the increased transparency requirements for all online intermediaries, the step towards some form of algorithmic transparency for very large online platforms, the strong regulatory oversight of the newly created digital services coordinators and the board and of course the commission, the potential for academics, vetted academics to access data from these very large platforms. This is quite important since indeed they have become hugely important for the formation of opinion. Now, on the first part of the proposal, we do see some vulnerabilities, specifically with regards to what the DSA gives us as instruments to fight against online piracy. There is one aspect that I would want to bring up, which is this complete exclusion from micro and very small enterprises from certain obligations in the DSA. We see this like a two-tier approach because such exclusions do not apply for new broadcasters, for startup, very small broadcasters. So it's just some sectors benefit from such exceptions. And on the more widely discussed aspects, we have some concerns, of course, surrounding liability. The concern that it's no longer the active-passive distinction that we all know and have grown to love, but it's now moving more towards the active-neutral distinction. We are concerned also with the introduction of this form of Good Samaritan principle. We see the notice and action not as unclear, but quite as burdensome, and we don't see how certain jurisprudence has been taken on board when drafting this system. For us, the provision of trusted flagger, yes, it could be helpful, but currently is quite unclear and has a requirement to represent collective interests of right holders, which for us is unfortunately not necessarily sufficient. There is also the limited scope of the trust of the Know Your Business customer. These are all areas that we see that require more reflection, and we are very ready and willing to work with the co-legislators and the Commission for a robust instrument. And now, just two words on the DMA. Everyone likes Hercules. Everyone likes Hercules. Everyone is a fan. We are a part of the plethora of industries that see this as a real answer to real business problems that exist, and indeed a huge step into leveling the playing field. What is important for us is for the scope to remain restricted to the undertakings that the regulation seeks to target, in fact. The scope and the definitions are important. The designation process is very important. And we would encourage co-regulators to tread lightly when discussing these matters. And of course, the do's and don'ts, but all that I'm sure we will discuss another time. Thank you so much.
Absolutely. Thank you, Miruna. Well, the word platform has been mentioned so many times today that it's time to welcome them on stage. So I would like to invite now Miriam Estrin on screen. She represents Google. Platforms have been mentioned several times. We are all eager to know how you see this. Is it something you like? Is the shoe hurting somewhere? Miriam, the screen is yours.
Thank you, Maya, for the opportunity to participate on behalf of Google. I will ground my comments in the DSA. That's where my main focus and expertise is in. And let me just say, I really like this framing of one area that we like and maybe perhaps one area where we have some constructive feedback, because that is the spirit with which we are approaching the regulation. We want to be constructive. We do understand our responsibilities here. We do see, like others who've spoken before me, a need for an updated regulatory framework. And I think we have a lot of experience building out our due diligence system. So we do think we have a lot to add to the debate. So I will get to it. One area I appreciate is that the Commission maintained the cornerstone principles from the e-commerce directive as a foundation for the DSA, and then built upon them with the due diligence obligations and the regulatory oversight. So that is, they retained a liability regime that is harmonized across all of the EU. It retains the prohibition on general monitoring. The regime is centered around illegal content, which helps businesses with legal clarity and certainty. And it recognizes the relevant differences between services, whether they are conduits or caching services or hosts or the Russian dolls that are nestled under that host category. And I just quote the Commission when they say that these are the foundation and the foundational principles of the digital economy, and that they're instrumental for protection of fundamental rights. And we really do agree. Those cornerstone principles have been vital to scaling up the single market. They have been vital for enabling that access to information, and likewise the ability for EU citizens to contribute with their creativity and their knowledge and their ideas. So I think that's a really good foundation upon which to build. So where do I see challenges? It stems from our experience in dealing with content moderation. We've put significant resources over many years towards building out our systems, our processes, to manage content challenges, whether it is cutting edge machine learning technology. We are industry leaders in voluntary transparency reporting. Our next YouTube report is due out imminently. We have scaled up the people, the policies, the processes that we use to work on content moderation. So it's through that experience that we'll be going through all of the due diligence obligations with an eye towards two things. One is to make sure that we, through those obligations, are devoting resources to building the tools that are most effective to keeping our users safe, that don't enable bad actors, that aren't just a mode of avoiding fines or compliance, but that really have impact. And then the second is to make sure that we are addressing the content challenges across the ecosystem. And maybe this is one for follow-up, but based on my experience in dealing with terrorist content or child safety content, or probably based on many of your experiences dealing with piracy content, we know that if certain obligations only apply to the largest platforms, the content will migrate to less regulated platforms that operate more in the shadows or with less scrutiny. So I think there's a way to still acknowledge the resource constraints of other players in the ecosystem while still making sure that we're addressing user safety across the entire ecosystem. So it's complex, and the DSA is very important to us and to the single market. So important we get the details right. And thanks, Maya, for having me.
Thanks, Miriam. So, well, it's not complex only for other players, but also you are now, adapting to new businesses. But I know that certainly there are some other people as well that are very busy, and that's in Ireland, because as Celine Craig from the Broadcasting Authority of Ireland can tell us, well, Ireland has been chosen as establishment country by many global players, and I'm sure that you are preparing for the new tasks that are ahead of you. So I was wondering, how does your midterm future look like? What are you doing to get prepared? And to you as well, what do you like and what do you think will be more difficult? Celine, the screen is yours.
Well, thank you, Maya, and thanks to previous speakers as well. Perhaps I can kick off my comments by welcoming the fact that the regulatory framework for online platform regulation has been updated, and I think the DSA, I will confine my comments to the DSA at the moment, but welcome the fact that this is a significant development in the framework for European legislation in respect of the oversight of platforms, and I think does give a strong sense of the intention and direction of travel of the European Union in this regard. I'm going to give the comments obviously from a content regulatory perspective. The AI is developing its position. As lots of the previous speakers have said, there's lots of complexity in the provisions. We're trying to work our way through it as everybody else is, and indeed we're doing that not just as an organisation ourselves, but also as a member of ERGA, the European regulatory group for audiovisual regulators. So I suppose I will keep my comments fairly high level. We're drilling into it in a bit of detail, but I think it might be important just at the outset, perhaps, to understand this from a content perspective. I think it's important that to understand that content regulators really see that the specificities of content regulation require quite a tailored approach to regulation and supervision. And that has been central both to IRGA's approach and it's one that we, as a regulator, as a content regulator, support. And that's not least because, its centrality really in promoting and upholding fundamental values such as freedom of expression, cultural diversity and human dignity, and even with dealing with more recent challenges such as online disinformation as well. That was part of the reason, that was the fundamental reason really why IRGA would have supported, for example, a graduated scheme of liability, having considered that the Good Samaritan principle was not sufficient because of the specificities of content regulation. But all of that said, I would like to perhaps, I think we can, overall, I think comments can be framed in terms of, some of these very positive aspects of the proposals. There's other areas as well that might welcome further debate and maybe clarification here and there. And there's one or two areas perhaps I'd point to where BAI is a regulator, and I believe other regulators also I think IRGA will be developing its position around this, but which I believe our views would be held fairly commonly amongst our colleagues in the European NRAs. And the high-level goals and objectives, I think, of the regulation, as I said earlier, have really strong merit, and they're broadly consistent, I think, with what BAI's policy approach, and I believe IRGA's policy approach would be to the regulation of content as well. I think the systematic approach is an approach that we've also actually strongly articulated. BAI in its own submission to government had articulated such an approach to the transposition of the Directive and the introduction of legislation on harmful online content. We'd also
Do you know already who will be the coordinator in Ireland? Is this a discussion? Because I don't think it's that straightforward, is it? Who will be the coordinator? Do you mean the
coordinator under the DSA, Maya, or do you mean the
Yeah, on the DSA. That's not
No, and I will. Can I come to that point? It will be my last point. I promise you, I will address it because I think, and this is not yet clear, and I think it's an area that needs a lot more debate and consideration. But just to perhaps just also say that I think the significant obligations on platforms around the transparency requirements and risk mitigating measures, all very, very welcome. Would also welcome the country of origin principle, the maintenance of the country of origin principle. Perhaps the DSA could have gone further, reflecting the close and efficient cooperation indeed that we're trying to establish within IRGA under a memorandum of understanding. We would really believe that there was potential to go quite a bit further in relation to putting more structure around that. But again, I can elaborate on that if needs be. I suppose just fundamental really to this approach to seeing content differently in terms of supervision and regulation is, I think, would under the DSA a clearer demarcation around the types of services, and in particular those that are dealing with media content versus those that are more marketplace type platforms. I think would be very, very welcome. And I mean, there's other areas I could mention here. I mean, we talked, Miriam mentioned there in relation to...
Just one last thing, otherwise I have to move on. So one last item.
Okay, I'll maybe raise one last item that I think is getting a lot of debate from content regulators, and we in the BAI would like to highlight it in particular, and that is around the regulatory structures that are proposed within the DSA. I mean, you raised a question there, Michael. I beg your pardon, Maya. You raised a question there around who would the coordinator be in Ireland. That's not clear. Indeed, I think it's not clear to a lot of content regulators because the DSA straddles various areas of regulation, copyright, it straddles, areas of competition law. So it's not clear. There's no easily identifiable coordinator. I think at the national level, there really would be a need to try and distinguish what the powers indeed of the Digital Services Coordinator and indeed how the board would work vis-a-vis in the context of the country of origin principle. We would also believe need a lot more fleshing out.
Thank you, Celine. I imagine it can be very complicated, absolutely. I'm looking at the chat box and I don't have direct questions to the stakeholders as such, which allows me to bring me on track for the time because we are a little bit beyond schedule. And I wanted to allow our experts to give their final impressions and takeaways, and also to Anna to react to what has been mentioned by the other stakeholders. I will maybe start with you, Anna. What is your takeaway from today in 1 minute? And then our three experts can get prepared for their 3 minutes, one each. Anna.
Thank you, Maya, and thanks to all the panel participants. A lot of inspiring ideas, very interesting. So if I may use a metaphor, Francisco's opening presentation inspired me. I see that we are going in the right direction, and what we could maybe aspire to agree upon, that what we are trying to put in place is a Greek temple. So probably not a futuristic building, but a Greek temple where we are now built with the DSA and to a certain degree also DMA. We are just building the roof. Some elements may need be redecorated, so there is some, room for improvement. As some of the panelists said, the devil is in the detail, but the direction of travel is right. But we should not forget about the pillars. And what I mean by the pillars probably is what I think many of the speakers already directly or indirectly mentioned as the existing sector-specific regulation that is so important, especially in the media sector, and that will continue to be very relevant for many of the issues that the creative sectors will be facing. Thank you.
Thank you, Anna. I like the temple. Very nice. I think we can make a nice drawing out of this conference afterwards. I would like now to hear maybe from Mark. What is your takeaway from today? Mark Cole, if we can have you on screen. 1 minute. With the microphone is better. No sound. Try now. No? Then I maybe ask Joan Barata to jump in, and then I'll take you later. So Joan, your takeaway in 1 minute of today, if we can have you on screen. The microphone, you as well. Wow, this is, I will try to see if I can manage from here. You are on? Try? No. This is incredible. Okay, well, let's try with Martin Senftleben, and then we try to go back again. You see if because I don't understand what's wrong. Martin, are you there for your takeaway? 1 minute?
I'm happy to give it a try. So I'm unmuted. I don't know.
No, you're fine.
You hear me? Oh, very good. So, well, I think I'm happy to follow up where Anna has just completed her comment. I think there is, of course, a lot of complexity now created with this DSA package, but as I see it, it's there's lots of opportunities there for softening a couple of effects that might have been a bit too harsh in the earlier, more specific legislative approaches, but also adding lots of new and important aspects for consumers, for businesses, for a level playing field. And so another point I want to make is that my impression today is that we are really having a good conversation about this. I mean, this is the most important issue in the further process, that we don't end up in particular camps, but really openly discuss the issues on the table and the best solutions to tackle it. So I hope that this is the beginning of a fruitful conversation on this. Thanks.
Certainly, thank you, Martin. We will certainly consider it as a kickoff. Shall we try with Mark Cole again, if we manage to have you on screen and with the sound?
I hope it.
Yes.
No idea what it was this time. What I wanted to say is that I was really happy with Anna's picture, because we have to get away from having to rely on a Russian doll system, but we find elements here. And I like the idea of the pillars, because if you would have gave me a choice about what I like, what I dislike, I would have also focused more on the DSA, because I think in the DSA we have the nitty-gritty details. Interestingly enough, hardly anyone commented on the DMA in the further process. That's not surprising for me, because the DMA is like, that's for the big ones. It's not an everyday element that will come into practice, much contrary to the DSA. But at the same time, I'm glad it was added, because relying only on competition law, and maybe that was not clear in my presentation before because it got swallowed, relying only on competition law retroactively is not enough because of the specificities of the network market. I think, just as an example, the Facebook WhatsApp takeover is a very illustrative example of how quickly the world changes, and how quickly also the assessment change. And that's why signaling to the market with the DMA, this is what we expect to happen, is already a big move forward, long before you think about sanctions. So that's why I think the comments have showed it's important we have both, even though the focus lays on the DSA. Thanks.
Thank you, Mark. That was sweet and short. Indeed, they go hand in hand, these two acts. Let's try with Joan, if the sound is back there, if we can have you on screen and also with the voice. You want to give it a try? No. Oh, that's terrible. Yeah, I don't know what we can do, because you appear okay here. So maybe you can write something in the chat box, and I am be happy to then share it with the rest of the audience. But in the meantime, since the clock is ticking, it's also time now for wrapping up the discussion. And we have had Suzanne Kolczeff, the Executive Director of the European Audiovisual Observatory, in listening mode for 1 hour and a half now. So if we can have Suzanne back on screen, there you are. I would like to ask you what your takeaway is of this long discussion. Suzanne, the screen is yours.
Okay, I hope you can hear me, and I hope you remember that.
All good.
Yeah, that there was a lot of talk about Herculean tasks. Now I think I have one right here and there, because we are talking about quite a package, not only the Digital Services Act and the Digital Markets Act, but also the 2 action plans, so some soft tools, and of course all the already existing directives that are only partly implemented. So this is really very rich. And let me maybe start by reiterating the main goals that Anna gave for the DSA in particular, and that was to protect fundamental rights. And I want to add maybe also in core values more principally. And by fundamental rights, she mentions the right to receive and impart information foremost. That, coupled with finding a good balance between public versus private enforcement of content standards. And maybe if we can add a third angle, that would be the one that Anna didn't mention, the DMA angle, which is actually strengthening, well, in a way, competition, so the level playing field, and also the position of users and consumers in this regard. Now, what's the target of all these legislative actions? The targets are the intermediaries in their various shapes, so whatever doll you pick, and here we have the first, I think, point to possibly look into it, because it was challenged whether those differences in size are really justified. So this I just wanted to mention right at the beginning. And the other target are, of course, the main gatekeepers. The tools used is to have more transparency, due process, cooperation obligations, also the obligation to be more proactive, and also control and redress procedures. Now, This is complemented by the sector-specific rules of the already existing directives. Now let me focus then on what the key challenges are that were mentioned. Obviously, the first and biggest one is to balance all the values and interests at stake. And when it comes to fundamental rights, we are very quickly at the issue of liability, because when I'm potentially liable, I might have a tendency to infringe of these rights of others by blocking content. And there we have learned that the e-commerce case law is not going to go away, but will most likely just get another additional layer, so things get more complicated, and this layer being the mitigation system, and also the obligations to take initiatives, which in a way leads then to the interesting question, when do we become knowledgeable, and what is actually the consequence of becoming knowledgeable? When will that have to mean that I have to really act in order to avoid liability? Then we had the economic interests that need to be balanced, and interest of users and consumers, and the question where we stand with the level playing field. It's getting more level, I think, is what I heard. The question is it already leveled enough? But all the industry, or most of the industry people felt this was really going in the very right direction. The scope of application is a biggie one here, and of course that leads us to various definitions that still needs to be concretized. And for example, what are large online platforms? What are gatekeepers? These are all key notions that need to be somehow defined. Then once we have all this, the next big task and challenge is to align the various instruments to best serve the commonly defined goals. So alignment takes place in various levels. The DMA and the DSA need to be somehow brought to be well, shall I say, intact, so to tango with each other in the right way. And this is also because platforms will really need to know what of the two, or maybe both, apply to them. And the same alignment has to take place with horizontal rules. So with the directive, with the sector-specific rules and the horizontal rules, so with the directives. And there we need a lot of coherence between new and the old rules. We are maybe having to discuss further what the interplay precisely is. So where does the scope of one demand some exclusivity, is preempting, or where is it really complementary what happens? That seems to be an understanding that the DSA is mainly meant to bring new aspects that weren't covered yet by the specific rules, for example, through the transparency and through things like trusted flaggers. But others might really still be only under the Audiovisual Media Service Directive. I know.
So do I understand it correctly, Suzanne, that there is still a lot of work for us to do here as Observatory?
There is for the Observatory.
No, so I guess there is work for us to do in the future.
There is lots of work for us to do. Also, let me just say one more thing, that the different entities have also to be put in line. So you have all these layers, but also the entities that have to work on all the instruments. And then, yes, the Observatory will be incredibly busy. And we knew that actually before we even devised this kickoff conference. So we already have contacted our advisory board, get a little bit more wisdom where we should have further information provided, and we will come up with a series of 4 webinars from March to July 2021. They will always be on Thursdays. They will always be from 16 to 17:15 in the afternoon, and they will always highlight practical aspects. The first will be on the 18th of March. It will concern itself with transparency of content moderation. We have already talked about the role of social media providers, who will be the focus of this. And we will see how do the new rules work in practice. This will be followed by the next webinar on the 22nd of April, where we will look in particular at gatekeepers in the DMA. And there we bring in our other department again, because we'll also ask really what is about the video on demand services here. This is the particular focus. So the gatekeeper position as to access to European Union audiences, and also on proprietary recommendation systems and data transparency. But we are still not done. On the 27th of May, we should concern ourselves with copyright and the DSA. There were a lot of also references made today to that, especially the various obligations of diligence imposed on online platforms under the copyright directive, under the Digital Services Act. And also notions like trusted flaggers or, for example, know your business customer. We had this at the beginning. And then the last webinar that we foresee, we want to dedicate on maybe the one that is most in the news, and that is disinformation in the DSA package. Just yesterday, the European Parliament discussed this issue, and I just would like to quote the Vice President Vera Jourova, who said, "We need to bring order to the digital expression of democracy and to end the digital Wild West." Well, we need to bring a little bit order and further information in what the DSA package has to say with regard to the disinformation. That's exactly what we like to do, focusing on the interplay with also the action plans that were mentioned by Anna Harold earlier. And then I would maybe just like to end this session by thanking our three experts. Mark shared your expertise and making things really clear, I think, to a lot of people. We had a great attendance. Thank you to our 6 panelists, Anna Herold, Richard Burnley, Miruna Herubanu, Pauline Durand-Vial, Miriam Estrin, and Celine Craig. And also to Francisco Cabrera for the introductory video. And last but not least, to our moderator, Maya Capello, and to all the participants. And if you have maybe too much time, think of using all these acronyms to do something that a German pop group has done, the Fantastischen Vier, Fantas, the Fantastic Four. They have used all German acronyms that they could possibly find and make it in a very animated song. So maybe that's something for the introductory video of our webinars. And with this, I wish you good afternoon, but please stay with us. Goodbye.